All right. Good morning to all you smiling faces on a Wednesday. Thanks for coming. I'd like to call the Will County Board Committee of the Whole meeting to order at 10:08 a.m. Pledge of Allegiance. Mr. Mahoney, would you like to lead us?
The United States of America, and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you. Jackie, can we have a roll call, please?
Richmond. Williams. Dean Schlottman. Ogalla. Pretzel. Butler. Newquist. Balich. Oxley. Brooks. Winfrey. Bullock. Logan. Freeman. Revis. Mitchell. Ortiz. Berkowitz. Hickey. Costa. Trenier. Van Dyne.
Present.
You have a quorum.
Thank you. Well, at this, yeah, I think at this point, only the folks here make a quorum, but nice transition. I do believe we do have a couple county board members that would like to participate today. And according to our ordinances, there are some reasons why there's an excused absence and county board members can participate. And in my opinion, since this is only informational, I would like to request this board to allow the county board members to participate via WebEx. So I would like to look for a motion to approve. We have a motion and a second by Mr. Richmond. Any discussion on that? Mr. Balich?
Yeah, I have no problem with voting to let people participate. I just don't, I want to make sure we never let them vote if they're not here.
Understood. Yeah. And there will not be a vote today. It's just informational. So that's why I made that suggestion. Any other comments? Can we have a roll, please?
Richmond. Williams. Newquist. Balich. Brooks. Winfrey. Freeman. Berkowitz. Hickey. Trenier. Van Dyne.
Yes.
Motion carries.
Thank you. All right. There are no approval of minutes today. So we will move on to public comment for agenda items only. Is there anyone from the public wishing to speak? Seeing none. No old business to be brought forward, I don't believe. So moving on to new business. This is for the presentation by the State's Attorney's Office for land use cases and also FOIA. So I would like to welcome the State's Attorney's Office, and it looks like we have Matt going to present this morning. So good morning, Matt. Go ahead and feel free to hit your button and.
Is that right? Can everybody hear me?
Yep.
Okay.
One question, Matt, do you prefer to give your presentation and wait for questioning at the end, or do you want to questions as we go along? What would you prefer?
It doesn't matter to me. You're probably, if you're like me, you like to question as you go along because you might think of something and forget about it later. So I don't mind being interrupted if you have a question.
Okay, I'll keep my eye open for lights being turned on, and I'll try to help you out there.
But I make no promises if I can answer your questions. Well, good morning, everyone.
Morning.
So essentially, I want to discuss my portion anyways, is in regards to, better? Good, okay. In regards to special use permits, map amendments, text amendments, or variances when you're seeking denials.
And more specifically, if you're talking about when you get a denial and there's a potential litigation or lawsuit that may result from it. And what we are talking about essentially is two different types of cause of actions that originate. You have they allege, plaintiffs allege against the county board and county board staff or county board chair and the members of a denial of either procedural due process or substantive due process. Those are the two main areas. More likely, you're going to see a violation alleged of a substantive due process violation. So let's quickly cover the procedural due process. And it's procedural due process. A plaintiff is merely entitled to notice of a proceeding and an opportunity to present their position. We satisfy that criteria practically every time. Staff does a great job. You put the notice out there, give them an opportunity to put their side, present their evidence in front of the county board and planning and zoning commission as to what they think they're entitled to. So we don't normally see in litigation a procedural due process violation. It's more along the lines that you're likely to see what's known as a substantive due process violation. And under such a challenge, when they make an allegation, when they sue the county, that there's a substantive due process violation, they're talking about a violation of what's known as the LaSalle/Sinclair factors. Why LaSalle-Sinclair? Those are the names of some cases that came down that decided. These are the things that a court should consider when they make a determination as to whether or not the county and the county board either rightfully or wrongfully denied the request that they were seeking. And what you're checking for, what the courts are checking for, is arbitrariness of the action that was taken by the county board. And so there are going to be, the LaSalle case mentioned 6 factors. The Sinclair case cited an additional 2 factors. And then there's, since those 8 factors, there's been other cases that have added or clarified those 8. And what are they? So the standards include the following. Number 1, the existing uses and the zoning of nearby property. And what I thought it'd be best is if we discussed each one rather than go through all 6, so you guys have an idea and you don't have to go back and what was he talking about in that. So the existing uses and the zoning of nearby property. Think of it, don't throw your common sense out the window when you're looking at these factors. The courts are going to look to the properties that are surrounding it and what's going on in that area. If you've got a all residential and someone wants to put something in there that's completely not residentially related, you know, it's not going to be in conformance with that particular factor. Oh, I should back up and mention one more thing. How and why did these factors come about? That's important to know. When these decisions came down, this LaSalle case was 1957 and the Sinclair case was 1960. When these cases came down, or when they were decided, courts and were all over the place. There was no general scheme as to what a court should look to determine, to see, did the county do right? Were they making the right decision? So LaSalle must have had some great law clerks working for the judges then, had them go out and pull decisions that took these factors into consideration, and they compiled them into this LaSalle case. The LaSalle case gave you the factors. Same thing happened with the Sinclair. In case you're wondering, where did these decisions, or where did these factors come from? They weren't just random. These were other court decisions, and they pulled them all into this. Because what Will County has as its factors, and staff will test what they are if you have questions on them, but what Will County has for its specific factors may not mirror what Kane County has or what Grundy County has. But these were the general prevailing notions considered at that time. And so that's what the LaSalle case pulled all these decisions and got these factors. We'll get to it in a minute towards the end, but does that mean that the factors that Will County has in its ordinances are out the window? No. There's other cases that talk about, in fact, I have it, that says, in addition, the court may also take into account any and all standards for this was special uses established by the legislative body. So if there's any other standards that may not mirror or mimic what's in LaSalle or the Sinclair cases, those are still legit. Those can still be considered by a court. All right. So we went through number one. Number two, the extent to which property values are diminished by the particular zoning restrictions. So if a plaintiff is making some sort of allegation on his particular piece of property that, hey, you know, this could be worth a lot more if you allow what I'm wanting to do, that's a factor. There's another thing I should clarify too, and I keep saying this word factor. Those are factors. Those are factors. There's 8 factors. There's litigation. I've handled a few of these cases already. What the courts are doing, keep this in mind, what the courts are doing is a balancing test. And they're wanting to see whether or not the scales are tipped more in favor of the plaintiff / applicant, they're the ones that applied, or the county, vis-a-vis the county board. And so it's going to look at arguments both for and against the applicant in relation to these particular factors. Do they favor the plaintiff or the applicant, or do they favor the county and the county board? So that's what they're looking at. It's a balancing test on all these factors. Okay. Number 3, the extent to which the destruction of property values of the plaintiff promotes the health, safety, morals, or general welfare of the public. So what do they mean by that? How much of the property values are going to be diminished in favor of promoting the health, safety, morals, or general welfare of the community? So if it's going to be, you know, the values are, it's going to be de minimis affected, yes.
So this has come up before in other situations that I've been involved in.
For land use cases?
Yes, but not here at the county level.
Okay.
I mean, it's an opinion of value and it changes. I mean, I bought my house for $239,000. At one point, I don't even think I could have gotten $200,000 for it.
Mhm.
Now it's worth $425,000. The opinions change over time. Nobody new moved into my neighborhood. They didn't, build a factory across the street or a trucking terminal, nor did they not build one. You know what I mean?
Mhm.
And so it's all opinions.
Well, it is, and that's what you're going to have a lot of. And when you deal with these cases, you're going to have hired experts to come in and testify about land values.
But you don't even know the opinions until you actually go to sell the property.
But it's more important when, I think you hit on this, as to it changes, right?
Right.
Okay. It's going to be at the time that case is being heard. Court can't speculate and make a determination what it's going to be worth 10, 15 years down the road. It's going to determine, what's going to be determinative is at the time this case is being heard.
Okay.
All
But do
right?
they take into consideration the overall economy? I mean, think about the housing market in 2008. Everybody's houses went in the toilet,
Yeah.
but it had nothing to do with anything that was being built anywhere around your home.
They're going to take the value. Well, you have to take it in context of what the factor is. It's the.
Yeah, I just had looked that up so I could, because I'm familiar with the Douglas factors, but not the LaSalle.
LaSalle Sinclair, yeah. So it says, again, number 3, the extent to which the destruction of the property values, or how much is the property going to be minimized, the applicants, to promote the health, safety, morals, or general welfare. So the property at the time the case is being heard may not be worth a heck of a lot. It's a piece of farmland, but you can't grow anything on it, right? It's going to be hard to make an argument to say that that particular applicant is losing a lot of value to farm it or whatever they want to do for it if it can't be used for farming. It's going to be relative as to the time the application is being heard. I think that's important.
So the whole economy, not just maybe well, anyway, go ahead. It's just seems very much an opinion and we all have one.
A lot of them are opinions. That's where you have those experts come in.
Matt, one quick, we do have another comment. I think that might come in. Sherry?
Thank you. So you know how it goes in land use. We usually have competing experts.
Mhm.
I mean, how do you reconcile? How do the courts reconcile competing experts?
The benefit of the doubt, if it's a decision that is supported by what happened and it's reasonably or rationally related, there's deference given to the decision of the county board. It's not your burden, or it's the applicant's burden to show that your decision was not rationally related to what you were trying to achieve.
Okay, got it.
And that's always the case. They have to overcome that burden. And I apologize, I should have brought that up in the beginning. There's a presumption of validity. Okay? Number 4, the relative gain to the public as compared to the hardship imposed upon the property owner. So again, there's that balancing test you're looking at is what type of, is this going to be something, the relative gain to the public as compared to the hardship imposed? So is it going to benefit either the applicants or the county in general to allow this person to do what they want to do? If the scales are leaning towards the county, that the hardship on them is very minimal. They can do a whole bunch of other things with it, but it would do a wealth of gain to the county to protect it from what they, the county doesn't want to happen on that piece of property. It's going to weigh in our favor or the county's favor. Okay. Again, keep in mind in the back of your head, all of these are balancing tests, the courts do. Number 5, the suitability of the subject property for the zone purposes. If it's something that the staff's report give a lot of opinion and gives an idea as to what's going on in that particular area of the county. If it looks as if this, it's leaning towards gas stations or whatever the case may be, maybe it is suitable. But if it's something that they're asking that's just completely out of, what should be in that particular area, that's going to lean towards denying it and be proper to deny it based on this factor in favor of the county. Number 6, the length of time the property has been vacant. That's usually considered in the context of land development in the area. So you don't see that a lot unless you're dealing with the case where the property is vacant. Property's been vacant for 20 years because they can't do something. And then here they got somebody that comes across and says, hey, I want to do something with it. It's a pretty good argument to allow them to do something there because it's been sitting for 20 years because they can't do anything else with it. And so that would be the sale. Those are the 6 factors. Here's a couple.
May I interrupt again,
Yeah,
please?
sure.
Mr. Balich would like to make a comment.
Yes.
Just like a little clarification. Say like Lewis Airport, that's it's in Dave Oxley's district. And it's a upgrowing airport.
Mhm.
They built some real nice houses to the west. So if Lewis decided to add runways, and that would affect those houses, is that like, you're talking about a balancing act?
Yep.
So would the airplanes that might crash or the noise or whatever else, is that something that we're supposed to consider as a hardship on the balancing act side for the people saying they don't want the airport runways?
Well, I think what you'd have, just as an example in this situation. I'm sorry.
Just need a little more clarification.
Well, I think you're probably going to have experts come in and testify, right? You're going to have someone come in there and say, hey, if we don't have these other 2 runways added to it, there's going to be some major problems or issues, like you're saying, crashes. Versus if you're going to have on the other side, neighbors that are going to complain and say, we already have noise up the wazoo. It's just too uncontrolled. And if you add 2 more runways, it's going to make it even worse. There's your balancing test. It's going to matter. Well, that's just one of the 8 factors you're going to be considering. So yeah, that probably would something that would fall into that balancing. You'd have to take that into consideration because I'm sure you're probably going to have experts on both sides. There's no one clear-cut definitive answer. It's just that these are some guidance that the courts use because you're not going to have one clear-cut answer for all of these issues.
So the
arise.
county board in essence becomes judge and jury.
When you make these decisions, you should be thinking like that.
I mean, because if I lived there and they're going to put a runway more, I'd say, forget about it. You can't do it.
Yeah,
And then they're going to say they need to make more money.
okay. So that,
So you follow what I'm talking about?
yeah, but
So
consider
you're not giving me a clear, in other words, you're just saying it's a 50-50 and we got to just figure it out.
Did you hear me say anything about making more money as one of the factors?
No,
There you go.
but I mean, what other reason could,
Well, the safety, they could come in here and make in a position or a point that says we need 2 more runways. Why? Why do you need 2 more? Well, it's a safety matters. So there is something that's going to benefit them.
I get it. I just wanted to make sure that what you're saying is that we're the ones that decide which way the balance goes.
Well, these are what the courts are going to look to make a determination as to what was decided here was proper. is what I'm telling. And there are cases out there, and I don't have them off the top of my head, but trust me, they're out there. I've seen them, that talks about that money, making more money, that's not a factor. And the courts don't give a hoot about that. That's not going to be a legit factor. There is what they call the highest and best use that they make. That argument is made, but that goes towards the use of that particular piece of property is going to be beneficial based on this highest and best use, and it's not going to do much harm to the community. So we think this is a legitimate and proper use. But you're not going to see a court say, we made our decision on this particular factor based on they made a claim and make a lot of money off of this.
Well, see, what I'm getting at is like, if you're going for a special use permit, I figured the airport's there first. So they're stuck,
That's,
so whatever happens, happens.
go
What
ahead.
you're saying is that's not the case, that if it's if we decide it's an extreme hardship, then we vote against it.
I think you've got to look to the factors and keep that in mind when you make your decisions. In other words, you won't go wrong if you look to these factors.
So it's not a matter of who was there first either.
I don't think that's going to be a controlling factor. Who was there first?
That's kind of what I always went by, that factor. If it was there first, forget about it.
Yeah,
I'm gonna go with the guy that was there first.
I don't think that's, I mean, unless Kevin, you disagree with me.
Well, what I was going to say is I don't know that this specific scenario is even really suited to the things Matt's talking about because it's already zoned for an airport. Unless there's some sort of change, and I don't know, Brian, do we have different categories of airports?
Or need a special use permit for something out there.
And you're also going to have FAA probably weighing in on this. So it's probably not a great application to the thing that Matt's bringing up because all the use is existing already in that case.
Because it may not be a special use permit that's being sought because of that factor. It's already
Alright.
existing.
Thank you, Steve. We,
Use that. They gotta expand their. A trucking company wants to expand their surface land that they have so they can put more trucks in.
Well, again, you got,
So if that, like, we have Cutler Trucking over in Homer. All right, if he wanted to expand more on his land, he's been there for 40 years. So he's grandfathered in all his stuff. But if he wants to expand it, just because he's been there, it don't matter.
well, I think it depends on what they're seeking. If they're looking for an expansion that requires a special use permit, then yes, you're going to look to these factors. Yeah, but the fact that he's been there for a long time is going to lend credence to, this is an appropriate use there, right? It's been
Yeah,
there.
so he's there ready and he wants to expand. So you say, okay,
But
is
I
your
think what you gotta look,
balancing act
I
thing-
think you gotta look now, is that expansion gonna have an effect on neighboring properties? Is it going to affect the values of,
Yeah,
property?
there's a lot of
Would-
homes right behind him.
Would there be a benefit that the community needs by his expansion? Or would it be detrimental to the people that live nearby?
That's kind of where I was getting at. What
All
are
of
they
those are
going-
things you consider. Yeah, I'll
Okay.
consider those.
Thank you.
Yeah.
Uh,
And then,
Mr. Guzman, I'm
Yeah.
sorry. We do have a couple questions and just a reminder, everybody in their own district has probably a circumstance where they could probably ask questions on each individual case. I don't know if that's the time and place for this. It's more informational on these factors. So if we have questions on the factors, let's leave our personal issues for another time if we can. So I have Micah and then Julie.
Thank you. I kept turning mine off because we kept having feedback and I noticed
Sure.
if there's too many on, that happens. Could you repeat number 5? I did not catch that one.
the suitability, I'm sorry, can you hear me?
Yes.
The suitability of the subject property for the zone purposes. So does it appear as if the property itself, does it seem it should remain zoned, whatever it is? Or should it be that the trend is like going, surrounding the property, zone something differently that, yeah, it wouldn't harm it to be changed zoning for whatever it's doing? That's.
Okay. Thank you. I was taking notes on the other one. I didn't get that.
That's fine. Okay. so-
Julie, I'm sorry.
I'm sorry, you had one more, yes.
Okay, thank you. So I'm a little, well, not confused, but I didn't realize that this committee of the whole was to specifically discuss that one land use case, because that's basically what you're doing, right? You referenced the parcels hadn't been used for decades.
I'm not
You're-
discussing any
you're
one
ref-
particular case.
Okay, so when you said, that the parcels hadn't been used for decades, what were you referencing? What parcels?
That was an example, just an example. There was one of the factors that the courts consider is number 6, the last one. Okay, and that's what, these are, again, from the LaSalle case. And their factor
Okay.
number 6 from that is, it says this, the length of time the property has been vacant as zoned considered in the context of land development in the area in the vicinity of the subject property. That would apply when you're dealing with a piece of property that's been sitting vacant for a long time. And
Oh,
the
okay.
landowner can't get use of that vacant property.
Okay, however, that's not necessarily the case, and
That's correct.
it isn't the case,
That's
but
correct.
that's just one of these,
That's correct.
okay,
Yeah.
okay. So I just want to make that clear. We are not discussing a particular land use
That is
case.
correct.
We are here to discuss the process and, okay.
And the factors
when-
that the
when-
courts take into consideration, whether
Correct.
the applicant or the county is right in their decision.
Correct.
Because you may have a piece
So-
of property that's not vacant. I mean, it happens. You have a piece of property that's vacant, but not all the time. That factor may not even
Mhm.
come into play.
Mm-hmm. Well, what happens if, let's say people we call vacant land agricultural land that's farmed, which to me makes no sense.
Right.
It's farmland,
Right.
it's agriculture. It shouldn't be called vacant land.
Mhm.
That should be changed. When I got on the board, I said, this needs to be changed.
I
Hasn't.
see your point. Yeah, I mean,
Uh-huh.
farmland, it's not vacant. It's being used for farming.
Exactly.
Yeah.
So.
I think what they were talking about in this context is they pulled cases that you have a vacant lot and there's nothing happening. Corner lot, there's nothing there. Building got demolished and it's been sitting there for 10, 15 years because nobody wants to build on it or something like that. Lo and behold, out of the blue comes some person that says, I want to do something with that corner lot. It's been sitting 10, 15 years vacant. And I don't think they're talking about farmland.
Mhm. Okay, so there will be this review, or they're going to look at the circumstances, and will they be looking at what the plaintiff says versus the county board? Is that what?
That's what the courts are doing.
Okay.
Yep.
And what happens if there's, there isn't unity within the county board? Because a lot of cases, there isn't.
I think they're just looking at to what the decision was made by the county board as a whole.
Okay.
Yep.
Thank you.
Okay.
Thank you, Julie. Yeah, Jackie?
Do they look at the transcript from the board meeting?
They will look at those and trust me, plaintiff's attorneys will look at the transcripts of the
I
county
kind of
board.
figured as much. I just wanted to confirm. Thank
Yes,
you.
they do.
All right, continue, sir.
Thank you. So the Sinclair case pulled 2 other additional factors. Am I missing? Is anybody else any comments on those before I go any further? No question? No? No? Okay. So Sinclair pulled 2 additional factors. The community's need for the proposed use and the care with which the community has planned its land use development. So the first of those 2 is that if there is a particular need for what an applicant is looking to develop there, and it was yet denied, there's a strong argument to be said that, well, maybe the decision was wrong because the community really needs this and could use this particular use. That's what that factor is saying. Yes,
Need or want?
it says need.
That's interesting.
The community's
'cause
need for the proposed
I
use.
may think I need something,
Yeah.
but I'm really just wanting it.
That's going to be argument then. You'll be making those arguments in court if you're going to do that.
Would public safety apply to this at all?
I-
Because need is, sometimes their desire is based on public safety. This isn't safe
Whose desire? The applicant or the county?
either, I mean,
Well, the courts aren't going to throw common sense out the window. They're going to look to, these are things that at the time, again, 57 and 1960, the opinions were all over the place. So they needed some guidance. But I don't think they're going to throw any common sense out the window. If safety is going to be an issue, I'm sure that that's something that will be argued. Okay. And then, so the communities need, the second one, the care with which community has planned its land use development. And that's where we're talking about the, what do they call it? You guys call that the plan?
Land Resource Management Plan.
LRMP. So you may have a community, like Will County, we have the LRMP, Land Resource Management Plan. We care how we're going to develop our property, so much so that we have a plan that we say this particular property is designated this and this and this, and this is how we want to develop it in the future. Some communities may not have that. So if they don't care about having how they're going to have their property developed, why should the courts care now in this particular argument? In other words, the county's argument in that situation may mean very little compared to some county like Will, that we have a land resource management plan that does care. Yeah.
So the only one I have was from pre-2012, when there were 9 county board districts and 3 county board members in each district. Can somebody get me an updated one?
On, oh, land resource
Yeah,
management
this
plan?
is from 2011. That's what I've been looking at.
Board Member Trenier, that is the current plan. Right now, the department staff is working on a update, and that will probably be coming before this board within the next year or so.
Thank you.
2 more questions. Sherry Newquist and then Kelly Hickey.
So how do the courts define community? And what I mean by that is a lot of times in land use, we run into the situation where the applicant, of course, is unincorporated, Will County, or we wouldn't be hearing it. But the community that's objecting is a municipality where the area in question is part of their overall planning radius, but they don't own the land, they don't, have any say-so in it. It's just they have it earmarked for future development. So in that context, how would the courts look at community?
That's a great question, and I don't have a clear-cut answer on that. What would be the community? That's a very good question. But I would think, the decision is going to be made, well, like you said, it's obviously being planned in unincorporated Will County in our example. The final say is going to be here. So I would suspect that it's going to be, if I had to venture to guess at this point, it would be countywide, right? Because the municipality is not having the final say. They don't get to vote yay or nay to keep this or not. It's this body. So if I had to guess at this, I would suspect that I would encourage that it look at it countywide. All right.
Okay, and Matt, not to make it harder.
Wait, my mic don't work. I'm sorry.
If it is at like the border of the county,
Mhm.
do you have to take in the contiguous counties?
Like if they have legal objection or something like
Correct.
that. So I think it matters on what the request is being made, because this is an analysis that the court's going to go through. If you're looking at the map and text amendments, right, where you have the legal objections, those are where they're going to have an effect on the ultimate vote for the county board to approve it, right? A map or a text amendment. You're going to need a supermajority if you get one for that. It won't have an effect on the vote that this body makes, but it's certainly going to have an effect on what you're thinking, right? You're going to have a municipality that's voiced their concerns, passed a resolution and tendered it to the county, and said, hey, we're perturbed by this. We don't want this. It's not going to affect your vote, but it certainly is going to affect what your thoughts are. And, if they're right on the border of it, then obviously it's probably going to have some weight in your vote. But I'm simply telling you for purposes of what's a community, I'd say Will County.
Okay,
is the
thank you.
Okay.
Hey, Matt, I just had a follow-up question. When we're talking about land use now, but does what you're saying apply to all the roads or any kind of public works project or a
No,
public safety project?
These are specific to this.
Just
Sure,
land
fair.
use?
Yes.
Okay.
Yep. Yeah, good question. Okay, so just to add a few minor points at the very end here. The courts do take these factors to determine whether or not The county board's decision was reasonably related to a legitimate government interest. And so reasonableness is the key here. And again, remember that there is a presumption that the actions taken by this body is legit. It was rationally related to what was happening then. And the burden falls on the person who's suing the plaintiff, the applicant, to prove otherwise. It's not our burden to prove it is until they prove that it wasn't. Then we have to go back and fix that. It is a balancing test for each individual factor. There was one final thing. Oh yeah, I forgot to add this. There was a case in 82 that talked about these counties that said that the courts can also take into consideration and into account any and all standards that were established by the legislative body. That's what I was mentioning earlier. Our regulations that we have in our zoning ordinance, they may not mirror or mimic exactly those 8 standards I gave you, but that case basically says the courts can also look to those to see, oh, well, you know what? The county's got 3 other ones that aren't exactly the same, and they all weigh favor and heavily favor in front of the county. That's a balancing test leaning more towards what the county did was proper. Okay. It is the plaintiff's burden to prove by clear and convincing evidence that the denial was what they call arbitrary, capricious, and unreasonable. And so you've heard that term before. They basically are making an argument that said they had no legitimate reason to do what they did. It was arbitrary, capricious. That's what they always argue. That's all I've got.
Okay, let's open it up to some questions on the 8 factors, right? Jackie, go ahead.
2 questions. One, are we going to get a copy of that?
That would have been my request too. That'd be very handy to have.
I will put the list down for all of
Yeah.
these, and I'll make sure that we get it to somebody who gets it to all of you.
Okay. And yes, thank you, because she's writing like a demon over here. And
No,
I
I can't give you a list.
thought I
if
was
you wrote
going to
it
have to go
down.
back and read all the meeting minutes, and I thought, I can read them, but I'd really rather just have your list.
Sure.
And then secondly, I thought we were going to hear a little bit more about our duties, responsibilities, boundaries as it pertains to these cases, how we should approach them. I know Mary Tatro talked quite a bit. And at the end of the conversation, I was still rather confused. Should I meet with constituents that are for or against a project, or should I not meet with them?
You wanna take this one too?
Because you get evidence presented and opinions presented and emotions presented at these meetings. And in fact, I actually felt
Yes.
stalked and battered by residents. And I was very, very uncomfortable. I mean, a man was insisting I had to come to his house and meet his children and see his yard. Yeah.
I would say, why don't you come to the meeting at county board and discuss it, or the PCC, and better PCC.
That's a better answer
Yes,
to these
and
folks,
say-
because then it gets into the public record.
Absolutely. Say, you want that part of the record. You want that to be made so that everybody knows about it, not just me. And that's what I would suggest.
That's kind of how I felt. I mean, but
Yep.
I also put them off to call their own county board member and not me. But, so I wanted to make sure that
I
everybody,
think anytime, just my humble opinion here, if you've got, and you're confronted with that situation, that's your safest answer for not only you, but for us, that we have to litigate these matters.
it would have been so nice to hear that 17 years ago. Thank you very much.
Yeah, just, come to PCC, put it on a record. It's in the record. You've got it. Everybody can hear about it, and now it's preserved.
Am I right? I mean, wouldn't you have liked to have heard it?
Kevin, would you want to chime?
Yeah, and so I think the safest way to just look at this overall, and to Mr. Balich's point about whether these factors apply to other things, is you should be looking at these land use decisions in a box. They are different than everything else county board, for all the reasons that Matt talked about. And I've said this a couple times, is you guys are sitting essentially as judges. So think about what you'd do if you were a judge sitting on a murder trial or something like that. You wouldn't just offhand go visit the site by yourself. You wouldn't go talk to witnesses by yourself. You're supposed to be confining to yourself what's happening in your quote unquote courtroom. And so all those things are extraneous things.
I would just encourage the folks that represent from the state's attorney's office on that committee to make sure that that gets ingrained to county board members, because it doesn't. I mean, if anybody ever said that in my 17 years, I don't recall it. And that just means I didn't hear it enough. Just because you say it once doesn't mean I'm going to remember it. I have a busy life. This is, not my 9 to 5 full-time commitment, 7 days a week. I don't own the county. It's different.
So we've covered 12, right?
But I think it bears repeating,
I agree.
perhaps even at every committee or at the beginning of any hearings or testimony or public comment.
I think it's a good point. I really do. I think that, it protects you guys, right? It protects you from being exposed to an uncomfortable situation, number one. Maybe. You might know the person. I don't know.
It was uncomfortable.
Okay, so there's that. But then, more importantly, for the county level, you've got it on the record, and it's not just you hearing it. It's everybody hearing it, and should it go to litigation, guess what? It's in the minutes. It's something that we can point to. It says, there it is. There's the person. That's what he said.
All right, we have, gentlemen, feel free to jump in as needed. We have about 4 lights are on as I see them now.
I have a question.
I have, Mr. Brooks has been waiting some time. Go ahead.
Oh, thank you. Matt, I thought you did a good job with your presentation. However, there's some questions asked in the audience, and I didn't quite understand the answer. I do like that answer you gave Jackie. I think that would have been wonderful with the Tuesday, inviting Tuesday. And I thought that's fantastic. There was a question came up from the audience about the word grandfather in, and I hear that quite a bit. There are some zoning cases, and your answer sound like to me, I think Steve asked the question, I'm a grandfather, so I have all rights and privileges in the world. You can't touch me because I'm a grandfather.
You were there.
Does that apply? Is that your explanation when a case is grandfathered in, that the zones of land use do not apply and or they get a special exemption because they're grandfather? Help me understand that.
Okay, so I think it'd probably be a question better for you guys to answer in regards to what they mean by grandfather. But just let me take a stab at it real quick. What I think you're saying is that this is a use that a person is using their property for a particular use that predates any changes of zoning or requirements that may have come into effect later for their property. So I take it for grandfathers, that's what I take it to mean, is that this is a use that they're making on a property that predates any changes that were made later that says, no, you can't do that, or you need to do X, Y, and Z. Is that right, how we interpret a grandfathered use we're talking about, the use that existed beforehand?
Matt, I think you covered, the basics of grandfathering. There really isn't a whole lot to add to it. If I did add anything, I would say in most cases, we would be able to prove that the use was legally established. And then the law changed later, which the zoning code has provisions for to allow that use to continue until it's discontinued. But there are limits to grandfathering where you can't necessarily, if the regulations have changed, you can't add to it beyond what it was before. So if somebody wants to expand on it, now they're going to have to correct the situation.
And also, I think that goes hand in hand with not only expand, or if they discontinue the use, that affects it, or if there's I think, what is it, like a fire happens or something, like it gets destroyed, their use or something like that, and they want to go ahead and make corrections or something, you don't get the benefit of saying, oh, I get to put up this shanty that I had up before because it existed before. Nope, now you got to come up to code.
I'm a grandfather.
We do have a long list of participants here, so I see Julie and then Sherry next.
Thank you, Joe. So I appreciate your comments regarding the actions of county board members and constituents. But what about when county board members are contracted or contacted by the contractors, the project managers, the unions, attorneys, how is that appropriate?
Why are they contacting you?
Well, I'm just saying, if it happens, what is your recommendation
First, I got,
about that?
okay, well, I think I need to first know why are they contacting somebody?
Well, we're not talking about specific land use cases, but
Okay.
it happens a lot with land use cases.
Well, again,
So what do you recommend to county board members if you're, unions are calling you, lawyers are calling you, contractors are calling you?
so again, I have to go back again. I mean, just to make it simple, if they're contacting you to wish you happy birthday, but if they're not coming to contact you to wish you a happy birthday, and it's regarding a zoning case that's going to be coming forward to you, I agree with Kevin. It's going to be coming before you. You got to act and think that you're going to be as a judge, and it's going to come before you to make a decision. PZC, you're more than welcome to come in here and give all you want to talk about. The floor will be yours. Because again, it always boils down to the fact that, here's where it matters, right? This is where the decision is made. It isn't made in a street or a phone call away. They get it here, it's on the record, you've got minutes for it. That's what it's going to matter.
Well, and so to me, that indicates that we should allow the public as many opportunities as is reasonable to express their voice with all of us present. And that's only at committee or only at full county board. Those are the only two opportunities that the public gets to have our voice, because we no longer read letters at the meetings. Now, they're just put on the agenda and every board member reads them. They don't get a voice anymore. You don't guarantee that every county board member is going to read those letters. So I just want to say that I think public comment, to allow the public to have the opportunity to speak at committee and at full county board meetings, I believe is important, and it should be honored by this county board. And I've just heard some conversation, this is under discussion, and those are my personal beliefs. I know people don't necessarily want a 3-hour board meeting, but when we have something that impacts thousands of people, I think that's our responsibility and our job. We stepped up to that. The other thing too is I believe that in some cases, certain issues which seem to be a little more emotional than others, I would like to have more direction come from possibly land use to help a smoother process. And I don't know if that's possible. I know they have a lot on their plate, but I kind of feel I don't want them to be out of the loop either. When you have 8 or 10 people, if they're going in different directions, nobody's on the same page. And at the end of the day, how can we make a good decision or the right decision when you've got all these, it's like where they say, I forget what they call it. One person whispers something and
Yeah.
the first person, then it goes 2 different
Sure.
directions. So, I would like us to make sure that I love this opportunity. I appreciate your time. And I really hope we can tweak our process where we need to and move forward. Thank you.
Thank you, Julie. Member Newquist?
Thank you. So I don't know if you guys really are aware of this, but being on land use for most of the, anything what I would consider a major case, I get phone calls from everybody involved. It's either the attorney or the project manager. Sometimes you get calls from the other side. And I am more than happy to say, I'm sorry, I can't discuss this with you outside of, either the land use committee meeting or the county board meeting. However, where it gets tricky and where I'm looking for some guidance is if the person contacting me is in my district. I mean, I'm their county board representative. How do I tell someone that I represent that I can't talk to them about this matter?
So I think you treat that the same. They've got to treat them all the same. Every person that, want to reach out to you, there's going to be occasions where it's going to slip through unintentionally or something that you weren't prepared for, right? They're going to catch you at an unwitting moment. But I think it's fair to say, to explain to them why. I mean, don't just simply say, I can't talk to you. Say, look, I appreciate your input and I appreciate the fact that you are in my district and I appreciate the fact that you have a concern such that you're willing to talk to me. However, it's going to be better, and don't you agree with me, it would be better if it had a bigger impact with the entire county board, not just me, because I'm just one vote. And so I think putting it in context for them, not just saying I can't talk to you, is to explain to them why. Because this is going to appear before you, just like a judge wouldn't talk to somebody, on the street or something about a case. Yeah, you're going to be like, I can't do that for the same reason, because I'm going to be voting on this. So if you were to appear at PZC, not only could I consider it, the whole county board can consider it, and it gets into the minutes.
And to back off this, I can't say this enough. A lot of these things, we talk about public comment, at these meetings. As I say, as much as I can, you can't consider public comment. They can come and make a great presentation at the public comment portion. You're limited to what happens in the public hearing. And so that person may make an impassioned speech and have all the facts and figures, and it completely sways your vote. And it's a good basis to change your vote. In terms of the way the law looks at it, it's like it never happened. When you're sitting for your deposition or testifying, you can't go back and say, well, my neighbor, Joe Smith, he's a expert architect and he gave all this information. The judge is going to say, well, did he testify during the public hearing? And if the answer is no, it's like Joe never made his comment.
Because at the public hearing, that's when it gets tested, right? The opposing side is present at that time. And they're there, that they have questions for that particular applicant or their counsel. You've had that before, right? Somebody who's protesting and says, well, I brought a lawyer. Okay, well, at the public hearing, PZC, that's where it can get contested. And that's why it has an effect and has meaning. That's what Kevin is saying. It doesn't matter if it's at a public statement, at a public comment part, but if it's at the public hearing, it will.
All right, I have, I'm pecking through this order here, guys. Member Hickey and then Member Bullock.
Thank you.
I know,
Okay.
trust me. As I see them come on, I'm being as fair as I possibly can. I have a list. No, I got you.
Okay, Matt, so
Steve, you're coming too.
what I'm hearing is there's a huge lack of public education going on. I know the county executive typically reads a statement that says, there'll be no new information considered. Can we get something that we can send? I mean, I get a lot of emails that are like, hey, will you come and meet with me? I've got something coming before the board.
Mhm.
And I'm like, as a member of the public, I think I would have thought that that's why we have board members. So I think that we're being perceived as shirking our responsibility if
Right.
we don't actually meet with them. So if it's for a legal reason, I would really like
Yeah.
a legal statement that I could
It's-
send to these people that would kind of just, yeah, and have that done every time when people are coming here to sign up for public comment. I guarantee you that we have had people sign up for public comment who think that those comments are going to come over into the decision that's made for our land use case.
Yeah, I think we can probably put something together and probably talk to Mary as well and see if we can come up with a uniform statement. But the gist of it, I think you get the gist of it, why we're saying this, right? You understand it.
Absolutely.
It's just simply saying that, public hearing, that's where it matters. Can't talk to you. I'm going to be a quote unquote judge. So I can't talk to you beforehand. I'd love to, but I have to be impartial when I make this decision. So that's it in a nutshell, essentially. But we'll see if we can put something together for you.
Thank you. And then one other thing is, how does this relate to solar farms?
You need to expand on it.
Well, I mean, my understanding is that with the legislation that came out in 2023, that there are 5 conditions that need to be met for a solar project. And if those 5 conditions are met, the expectation is that, from the state, is that the county board will approve the project. Do we even need to employ any of these LaSalle
No.
Sinclair factors?
No. I'm
Okay.
telling you right now, no. LaSalle Sinclair does not apply to those solar farms. They have other factors that have been specified and spelled out in a state statute that the county has drafted an ordinance that mirrors those. So those are the factors that they need to satisfy. And we rely upon the expertise of staff, who do a great job, by the way,
Yes.
to make sure that that criteria has been satisfied. And should it be so, I think we've given you our opinion on that time and time again, right?
All right, thank you. I appreciate that.
Yeah.
Member Bullock?
Couple questions. Why did we not go along with the original 8 factors?
Is-
What made us change ours so that they're a little different?
So we didn't change anything. Those have been since 1957 and 1960. And if you look at the wording on our factors that we consider, a lot of them are very similar. It's not exact, but it's similar.
But is there a reason for that? I mean, when, like, why are we making more work for ourselves? Like, these 8 are done, let's just use them. Is
Well,
there a reason that,
Well, I think because of the prior county boards took other factors into consideration when they were all originally developed. Those were important to them at the time. And so they put those in there. Could you change them? You probably could. But I think, that's the whole purpose of what LaSalle Sinclair came about. All these counties had all these different factors that existed out there, and the courts were going crazy. What's important? So the judges in LaSalle and the judges in Sinclair grabbed the most popular or the most, where there was a consensus, and put those into their decision, which is what has been guiding the courts since 1957, 1960.
okay. And then with the open hearing, is an open hearing, or should I say it this way, isn't an open hearing meant for factual presentation?
If you're in a hearing, that's what you're there for.
So,
And our hearing is PZC. That's where the one public hearing that the state requires is held in Will County. That's where it's been since time memorable, since I've been here.
so if we were to have an additional open hearing during county board meeting, and what was presented was not fact, but opinion and feelings, because it's in an open hearing, we take that into consideration?
You can disregard if it's, because the court's going to look to that as like, well, somebody, was crying about it. Well, they didn't give you any facts. I mean,
Okay.
they're going to look to the facts. What are the facts that were shown? Someone's opinion. I shouldn't say opinion because you're going to have experts' opinion, but someone who has their thoughts as to something that's speculative at best. That's what the court's going to say. That's speculation right there. You've had nobody, you didn't have an expert come in who gave his credentials and who he or she is, a land use appraiser or something like that, and has done studies on these types of projects and has make a determination that it's not going to affect the land value. That's a little different than someone coming in and says, I think it's going to hurt the property values of me, and it's someone who just lives nearby and I got nothing to back it. There's a difference. Do you see how one is backing with
Oh,
an
yeah.
opinion from an expert?
Yeah, so it's just kind of up to us to, filter and
Filter,
disregard.
Yeah.
There's no way that we could say, I'm sorry, that's not a fact. That's not part of the open hearing.
I don't even think you need to go that far. You know it in your head. That wasn't a fact, right? So,
But I'm looking from an educational standpoint and educating the public that this is what an open hearing is for,
Mhm.
and maybe this is what public comment is for.
Right. Your
Because-
decision is based on what happened at the hearing.
The factual information presented at the hearing.
At the hearing, correct. Goes hand in hand with what Kevin was just mentioning about a moment ago.
Thank you, Dawn. Micah Freeman?
Thank you. So, for instance, I have a land use case that's coming up next week sometime, at the PCC. As a board member, can I go, as their constituent, can I go look at their property, see what they're talking about? Is that okay, or should I just not do that at all?
Well, in what context are you going to be going for? Like, you're going to show up at PZC then and then have questions as well for the applicant and
Sometimes I do,
okay.
but it's, a lot of times people will say, well, this is in your district. Tell us what you think. And if you haven't gone by, if you haven't seen it, you have no clue. So I just,
I'm
as Member Hickey said, it's part, I feel like it's my responsibility as their board member to,
I'm still troubled by that. I'm not going to lie about going and visiting these sites. and
so I should
places
just not go
and
at
stuff.
all.
Yeah, I'm still, I don't know, Kevin, you got a pipe in?
Yeah, I was gonna say, I think at least, and this is just how my brain works, putting it back in the courtroom. If Matt and I are on the opposite sides of a case, you guys are sitting and listening to it, and the applicant, so you want to know all these things about the property, and the applicant just says, hey, I want my special use permit, give it to me. And you have all these questions that they don't have answers for. You don't have an affirmative obligation to figure out those things. It's on me as the attorney saying, Judge, just rule in my favor. I didn't put my case on, therefore, if they don't want to provide all these details, they can bring up, we've had all sorts of graphics and things like that. Aerial views. You don't necessarily need to go gather facts. It's on the applicant to bring those facts forward to you.
And that's always been the case. I mean, I'm not gonna lie, I've always felt uncomfortable when county board members go out to a particular site
Yeah.
and do these visits.
I think it's been very clear by the state attorney's office that they only want us to listen in on the public hearing to make our decision. They've stated that at least 20 times since in the last 6 months that I've been here.
Okay.
Yep.
So I have 3 more here. Mr. Balich, thank you for waiting.
My question to you is not anything you talked about yet. Prior to anything going to land use.
Yeah.
I get calls from a developer, a house owner, you name it. They call me and there's lots of them. A lot of times I'll just tell them to email me stuff after I talk to them and I look at what they want to do. And then I send it to Brian. I mean, I sent a lot of stuff to the county, to Brian, and, I figured that's the best way to handle it, make them aware. But there's other times that I'll look at a project, someone will come to me and, I don't want to use any for instances, but I'll have different people from not even my district call me and say, what do you think of this project? And they'll show me the project and I'll look at it and I'll tell them, yeah, it looks good. I don't see a problem with it. Sometimes I tell them I don't like it. There's a problem with this, this, and this, and this in my mind. And that's it. And then they have to determine themselves whether they want to move forward or not. Now, what is that? It's not a land use case. It's not even been presented. They didn't even go forward to do anything. They're just asking my opinion of what I think personally of their project. So am I supposed to tell them this may be in the future a project, so I can't talk to you?
I think if the matter is going to appear, if there's a chance,
Pardon me?
if there's a chance that what they're proposing is going to have to come before the county board for approval, and if it's not going to require you guys.
Well, they're basing their opinion whether they're going to move forward most of the time. Because I've told one for sure, I argued about it, and I argued on the county board about it, that, you're going to be changing the zoning, and the zoning's bad. That's why I'm against it. It's not the project, it's the zoning. I'm not going to support it.
Well, now you're prejudging it, and so that's even worse than going out there and looking at the property. You've already given your vote on that, haven't you? By doing it?
It was a storage place. You guys
Yeah,
remember that?
I remember.
We changed the zoning
Yeah.
from C2 to I1, and now we change it back, so it's a special use with C2.
Yeah.
But that place, they came to me. I said, I don't care about the storage part. I care about the zoning part.
Yeah.
And then we argued back. They came back another time, and I told them to annex it to the village. And then, so it's not always you're saying, yeah, do it. And it's a mix. Sometimes I tell them I don't like it. Sometimes I tell them I like it. And I'm not basing it on anything else than what I'm looking at, what they're showing me.
Yeah.
So I'm judging it by myself before they go. And a lot of times when I tell them I don't like it, they don't even bother to come.
Well, you got to go back to what we talked about a moment ago. That's even, I think what you're doing by giving your opinion on as to how you're going to vote on it is, with all due respect, worse than going out to visit the site, because now not only have you gotten information about the site, you've given them what you told them what you're going to vote on, right? Whether you liked it or
I
not.
tell them I like what the project is, but it's not even part of anything yet.
Well, okay, so that's first part is given of your prejudging what your vote would be. I don't agree with, and I don't think that's
So
appropriate. But I
gotta
also
tell them the
think,
same thing. Can't talk about it.
yeah, well, I think if it's a matter that's going to likely appear before you, right, as a county board, same rules apply. Same rules apply. Something, hey, I appreciate you calling me, but with all due respect, this is a matter that's most likely going to appear for me because you're seeking a special use permit or a map amendment or a text amendment. And, the decision needs to be made based on the facts as presented at the public hearing. This is not the public hearing. This is a phone call. Were you going to present for you? Yeah. Okay.
Leader Richmond?
Thank you. So first off, I can appreciate you guys coming here and giving us this information. To remember Trenier's point, this is 17 years too late. Well, and I think this goes back to what we were trying to do before, is do an orientation for new board members and old board members to refresh their memories on how we should and shouldn't act, behave, whatever you want to call it. And I'm not casting stones. I'm just saying that maybe what we need to do is go back to that orientation thing we talked about, because this would be helpful information. I don't think anybody in this room ever intends to do anything malicious or wrong or that. You men and women are looking at it from a legal perspective and a land use perspective. We're looking at it from a customer service perspective. I mean, being in business my whole life, not returning a phone call is, a mortal sin, which is a challenge. I mean, I said it the other day when I talk to customers, petitioners, whatever. I try and partition my brain and say, yeah, we're having a conversation, a casual conversation. I try not to go and cross any borders or anything like that, because you got to remember, most of the people that come before us for land use, they have no idea about government. We've been involved in government. We've been processing paperwork. We've been sitting in court and all that kind of stuff. How do we bridge the gap between that person that's trying to get a shed built or a roof on their house or build a storage facility and give them guidance so they don't keep thinking the government is, a four-letter word? I mean, that's what we're really looking for here. I mean, I think we can do it. The question is how are we going to get to that point? And I think what we need to do, Matt, your information is good. I appreciate it. That's good to give us that language, so we're all on the same talking point, or the same. We say the exact same thing, in so many words. Now the question is how do we get there? I do have a question. I'd like to piggyback on Julie. So this is kind of on her conversation. Public comment. When they come out to a caucus meeting, Kevin, you've showed up to a number of ours, and Mary has too, and we try and, limit the public comment. We try and engage because it does impact people or that kind of stuff. So that's something else do we use that same statement, Matt, that, hey, we'll give you your 3 minutes, but none of this can, have any impact on our decision-making process, because they're going to try and tug on your heartstrings, and in public comment, we're not supposed to interact with them, but, we got to say, let's stick to the facts. Let's not stick to emotions and all that kind of stuff. So that's the other challenging point I have. I think that's about it, but I do know we probably have some people online that may want to jump in too, Joe, so I'm sure those are probably on your list or that too.
For that point, I've been looking to see if anybody wants to turn on their microphone, and no one has yet.
No one
at
has,
this point.
okay.
I hit
So-
mine on now, Joe.
Just now?
Yeah, I didn't know when you wanted me to turn it on, so. this is
Yeah,
Judy.
okay. All right.
So
Ju-
that's all I had, thank you.
Yeah, thank you. I have 4 more individuals here that would like to speak, and then I will call on you. Okay, Judy? Jackie?
Just wanted to follow up on this continued debate about public comments, whether they're read into the record. Let me make sure that I understand. When we get public comments, do they read those during the public hearing?
I don't know.
They don't. So again, I would prefer to just get them attached to my email, and I can maybe try to partition my brain, as Member Richmond said, and not consider them because they're not a part of the public hearing. And the reason they can't be, as I understand it, is because you can't question the person because you're reading a document. So to me, there is no value that I can utilize in my decision-making by reading public comments that pertain specifically to land use cases, which most of what we get, that's usually what it's about. Not always, we occasionally get something else. But I think that needs to be made very clear. We are not taking away anybody's right. If they want to comment, they must come to a public hearing so that either side, pro or con, can question them or clarify any facts or information that they present. And I think we need to really keep hammering home on that because folks think that we are trying to cut off their ability to talk. No, we are not. And in fact, we should not be paying attention to those written comments per what you're telling us.
And I think the important thing there is that's not Matt's rule, that's not Kevin's rule, that's not land use's rule. That's the Constitution.
Correct.
It doesn't matter what the board, how the board would like to create certain things. What you're looking at, and I remember Richmond, I appreciate your point about the customer service here is the real frame of reference. What a court is going to look at though is whether that applicant's constitutional rights were impeded or harmed by this outside information. So it does put you in a tricky spot. We acknowledge that. And I certainly wish we could have presented this earlier. We had tried in the past to get this information. There were some other issues. We've not tried to shirk this issue. I wish we could have got it out there before we had all these big cases, but that is the real frame of reference here is the constitutional right of Joe landowner. And so all of these things, they do make it hard. I get it. And it makes Matt and I have to make these decisions. Look, this is what the county can support based on the case law and the Constitution. We get all of those decisions, but when we go into court, we can't, as much as we'd like to, argue those facts either. 7,000 people showed up, and we feel for them, but we can't argue that that's a relevant factor.
So
Sorry.
one more follow-up question on that. So we've heard a couple of times there have been online petitions, and we were supposed to give some sort of weight to these online petitions. 3,000 people signed a petition that they're against this, 300, whatever. Some of them not even from this state. But these things have been presented to us, not necessarily in a public hearing, but vis-a-vis email or just a public comment. Are those to be considered in any way, shape, or form? Since you can't question the signer.
It's going to be kind of hard if they haven't had a chance to been questioned, right?
Thank you.
Jim,
Oh,
I'm sorry, Julie. Jim
Yeah.
just he brought up Jim's subject, so I'm gonna let Jim piggyback off of that real quick, and then I'll go to you, Julie,
And
okay?
I apologize for jumping in front of anybody, but I wanted to keep the continuity of the conversation
Right.
going. So,
Right.
Thank you, Joe. Kevin, so you mentioned the keyword Constitution, which I totally want to abide by. So Matt, you said putting together a statement for us to read. Then what you could do is if you could parcel this all together for us, so that this way we can in turn say, here's what we're doing, and we're trying to protect your constitutional rights, then, so it's more than what, just a sentence, Matt, it's,
Due process.
Right.
there you go.
Due process.
Matt and I have bosses that'll have to weigh in on this, but I
Yeah,
think,
yeah.
and I'm sure Matt's thinking the same way, is what we're gonna do is probably pull from a case that says, the hallmark consideration here is the due process, and we'll probably even throw that in there. So you can put it in your email and say, look, this is my statement on it.
Yeah, because we're not trying to hide,
Right.
but because what do I always hear from my attorney? Is don't say anything,
Yeah.
let me do the talking.
Right.
So what I'm doing here now, guys, is I'm saying, I'm letting you guys do the talking.
Yeah.
All right, thank you.
And,
Thank you,
and
Joe.
with that, I think our county board staff can can try to get that out on social media. I know social media is not everything, but we could probably put out a statement of facts that we have learned recently. And then you folks would be more than happy to share those, and maybe we can even put out a press release to the newspapers as well, just to try to get that information out as best we can. I know you're not going to reach everyone, but at least we can try. All right, I have Julie and then Sherry Newquist.
Okay,
Julie,
thank you.
sorry.
All right, thank you. So again, some of these statements are referencing particular land use cases, which well, they really are, if you listen to what's being said. But I want to just kind of stick to the facts, because I come here and I want to do my job and I want to do it well. Land use cases, the cases that come before, we're dealing with private property, people who are paying property taxes and maybe want to put a shed on their land, and they have to go through a permitting process. And we are the ones that say yes or no. And we need to understand and have all of the information we need to make a decision, because we're dealing with people's property, their homes. Now, I'm going to be honest, at Land Use and Development, that committee meeting, they don't talk about a lot of the facts. They don't take the time to go through. Now, I'm sure every board member is doing it somewhere, maybe at home or something, but I feel like we have a responsibility to do the job right. And if you're saying we can't do this or shouldn't do this, sometimes this application, you may need to have some visual perspection. Or, you might, in order to make a decision, need to be able to see it. That's what people do sometimes, go out, take a look. They want to understand and know what they're voting on. So if we're restricted from doing that or having that contact, then is our land use department going to then provide that visual perspective? Or I mean, I'm just trying to understand how a county board member is going to be as knowledgeable as they should be when they're voting on whether or not somebody has the right to do something on their property that they pay taxes for.
And I think that goes back to the comment I made earlier, is it is on the applicant to establish the factors within whatever they're seeking, whether it's a special use or a zoning amendment. So,
Okay, so you've got Kevin, on that thought, I see where you're going. You've indicated that the public hearing, the critical or the only public hearing is at planning and zoning.
the only required one that.
Okay, so would it make sense that county board members on Land Use and Development Committee, they should be attending their planning and zoning meetings, shouldn't they?
That's their decision. Might as well.
If they want to understand the case
Well, I
and
think-
know that,
I think the facts that are presented are collected at the public zoning commission.
well, the minutes are difficult to read. Read their minutes. They're difficult to read. You actually need to be there. And I know because I go to those meetings quite a bit. But I at the end of the day, I understand what your message is, but we need to do our job right. We need to do it the right way. And to me, I don't feel comfortable. Now, if I don't have the ability to talk, to even have a conversation or to, I want more time then. Committee meetings, there's a pressure, 1 hour committee meeting, we're out of here. How do you do that? How do you do that when our land use cases are expanding?
So I think there was a suggestion of taking the second public hearing from county board and having it at the land use committee. That way, I think the land use staff can present during that public hearing as well. And then every county board member that can't make either planning and zoning or land use committee has the information that was presented at the public hearing. The way it's set up now, I don't believe the land use committee can even bring any information into the public hearing because they're not unless it's at planning and zoning. Anyway, let's move on. We do have FOIA to talk about as well, so I want to finish up the questioning. Sherry Newquist, Kelly Hickey, and then I want to call on Judy from back home, and then I will call on Micah, and hopefully any other questions, maybe we can, Jackie again.
Just a question.
All right, let's do that, Sherry.
Thank you. So I just want to make sure that I understand a couple things. I just want to make sure that I understand this though. A lot of times I will drive out and look at a land use site, but I don't contact the homeowner. I don't, I literally just drive the area because I want to put the site in context. I'm assuming that is allowable. Okay.
Matt, turn your mic on.
Better?
Yeah.
Okay, I'm still reluctant to even look at that as to say, yay, go ahead and do that.
Okay.
Again, it's just think of it as you're gathering facts outside of the official record, right?
Okay. Second of all, I've actually had people tell me that land use staff suggested that they contact me. So I definitely think that we need to educate land use staff as well. I mean, land use staff does a great job, and I'm not sure where this is coming from, but it's happened to me a couple times recently. So, and I'm not, maybe people are misinterpreting what they're saying,
Yeah.
but I think we need to be careful about what we're saying there.
Sure.
And third of all, I think you guys just kind of addressed it, is that I'm sitting here going, our land use meetings last 4 and 5 hours sometimes. Are you telling me that we're not allowed to use any of that information because it's not a public hearing? I mean, that makes zero sense.
Good point. Okay. Kelly Hickey.
Thank you. I really appreciate you coming here and giving us this advice, but I'm concerned when I hear some of the pushback. I would like it if you would explain what the possible ramifications are for ignoring this advice.
Absolutely.
And what the financial ramifications could be for our taxpayers.
That is a great question. And they are essentially, what are we discussing? We're discussing factors that a court's going to consider, right, in a litigation. Meaning, typical scenario, want a special use permit for X, Y, and Z. We say no, we being the county board, then we get sued. When it comes through depositions, because you could be deposed, it's happened, and some of you have already, those facts are going to come out. What did you consider in regards to blah, blah, blah? Your decision was based on such and such. That information, more likely than not, has already been exposed in the minutes. You've had, and you probably will continue to have comments made by, county board members that have stated, well, I'm a flat out blah, 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 and I'm not gonna, I don't care what the facts are, anybody says that, because I've seen some statements. And so that's what they're gonna hang their hat on. And so ultimately, it's gonna be a judge's decision based on these LaSalle Sinclair factors. If it was an arbitrary and capricious decision made because they weren't considered and they're not in the record, we lose. County loses. So what could happen then? You're going to get something on a piece of property that you didn't want for the wrong reasons. That's the ramifications. That's the end result. That's what they're looking for, is to have something built or constructed, typically on a piece of property, but we denied them the right to do so. That's the ramifications.
But it comes at a cost to taxpayers, right?
Absolutely. Our costs, litigation costs, outside counsel to assist us to do with these matters. Going to have to bring in staff, which I've done before, taking time off of what they're doing back at the office to testify in court. I don't think any of you guys have testified for me before, but bring in staff out there. Takes time from me doing other stuff and Kevin doing other stuff in the office. It's time in the courtroom, for sure. Yeah, so definitely comes at a cost to the taxpayers.
Matt, you've done more of these than I. is another consideration that, especially like in a, when conditions are put on the property, the judge may just order them without conditions. Look, they're getting this zoning.
Yeah.
There is no, 14 things we worked out with land use that are more palatable. It's, okay, now a warehouse is going in there and the warehouse is going in
Yeah.
by itself.
Yeah.
I think I've heard that before, but I
Yes.
know you've had more cases than I.
Yes, because when you have the special use permits that have been granted, condition them with the exception of solar farms we're talking about, but typical special use permit with conditions that are rationally related to the purpose of that special use permit. Court can say, you like you said, he had 15 conditions and, I'm not going to put any of those on there because I don't think they may have been rationally related, but if we kept and worked with them and granted them their special use permit and kept those conditions, we could lose those. That's a big deal, I think. Yeah.
All right. Judy, are you still with us?
Yes, I am.
Oh, perfect. Hey, good morning, Judy.
Good morning. Thank you. I would just want to say a couple things. It's like why I don't understand what the purpose of public comment is. People feel that they can come have a say in something, but everything they have to say means absolutely nothing. It's very bad being a member of the public. And I think those of us who are county board members, we ran for office to represent the people. And sometimes ordinances need to be changed and you don't know it needs to be changed until you look into certain situations, because I'll tell you, land use staff doesn't often offer a change in an ordinance that maybe was 10, 20, 30 years ago was good, but times have changed in that land use staff is not always going to be bringing that forward. Typically, a member of the board or the land use committee itself will bring something forward for a change. So unless you know some of the things, and like I said, times change, so things have to change. We're the ones that make the ordinances. We're going to be the ones making the changes. As Sherry Newquist mentioned, I also go out and I look at the site because during a meeting, you cannot look at all the information that's available because your iPad gets jammed up. I need to go out to physically see the site. I know we're provided with pictures, but the pictures are not always the same as when I'm looking at it. And by that, I mean, I can't get a bird's eye view from the pictures. I can't get a 360 view from the pictures. Yes, we get it looking northeast, but it's much different looking at each picture individually. And I read my material for the land use committee because I'm on that committee, but you can't possibly remember everything. And there's nothing shown to us often at the land use committee. They read ZC 25-642, whatever the number is, and they state it, but you would have to then have all that information in your mind to remember. And there are hundreds of pages in each land use case. So I think it's very difficult to sit there and make a decision. I know that we have the one hearing at planning and zoning, and planning and zoning gets to make some decisions because the board has granted them the right to make the variances, because typically we'd always say, yes, we would do the variance, we'd agree with the variance. So the Planning and Zoning Commission gets to do that. Those people are appointed people. They're not accountable to anybody. We are elected officials. We're accountable. I get it from your legal perspective. You guys look at it from the law area. From land use staff, they look from black and white, what it says in black and white. And sometimes when I've had conversations about situations, and finally I've asked like 14 questions, I asked the 15th and then my answer is there. Well, if I don't take the time and do that, I don't have that experience, and you're not always having that in a meeting. I think that we need then for sure then to have a public hearing, either as we do now at county board, which I like because then everybody's there. If not there, you have it at the land use committee. And by the way, land use staff can ask to speak at the county board meeting as long as we ask them to come up and speak. They don't just get to they don't speak at our meeting, except even at the land use committee meeting, they present the case and then they answer questions. So we could do that at wherever anyone decides to have a public hearing. I think that, it is concerning to say that we're being advised to not talk with the residents, to not go out to the site. We're the representative. How do we not do that? You guys are not representatives. You're employees of the county. You follow whatever rules there are, the laws that there are. And as we all know, everything can be looked at by 2 or 3 different people and you have a different opinion. I think as elected official, it's my responsibility to go out to the site and see what the people have. And sometimes you can advocate by just simply suggesting to them that they go here or they go speak with this person or whatever. They don't even know. So sometimes, like Steve had said, they'll call and contact you before a case comes forward. And sometimes they'll call and contact you. You give them information to contact land use department, find out this or that. And they don't even have to come to the board. So we don't always know what will or won't come to the board. And then finally, as a county board member, we have the right to appeal, to vote if the applicant appeals a decision that's made at PZC. They have the right to appeal that. So some of that information is, again, by going and looking at the site. So I hear what you're saying, Matt, but I find it very difficult to not speak to somebody and to not go to the site. Like I said, you're not an elected official. We are. It's very hard to tell your constituents, why I can't talk to you about that. Well, then why are we even there if they can't even talk to us? That makes no sense. And then another thing I wanted to mention was with the solar farms, the solar companies have contacted us all along. And from the very beginning, when this started through to now, and they used to contact the board members in the district when they were bringing a solar facility to that district. And what's been the advantage to that is we've been able to work with the state statute as it is and get things that are, understand things that the people want in the area, such as agricultural fencing versus chain link fencing. Whether we need landscaping around a solar facility out in the middle of the farmland or not. I mean, you have to physically go and see where it's located because, like I said, seeing it is believing it versus just a picture that you're shown. So I don't understand how I get where you're coming from, because if a lawsuit comes forward, there's concerns. And I do know that a lot of people say a lot of things in these meetings or in person, but if you are just speaking one-on-one, that doesn't determine anything. And I guess we could just have a conversation to say, I want to hear what you have to say, and then let them know that, you need to bring this forward at the public hearing so that everyone can hear the situation. But I don't know how we just totally don't go out and have that conversation. I really don't. And as far as one more thing too, you said it's the applicant's responsibility to bring something forward to prove it. As Steve said, that the applicant, they don't know anything. They're just a regular Joe living in their house, trying to live in their own house, while people who are being told not to have conversations with them, make these laws, make these ordinances without input from the people. How do we not bring people into this? How do we not do that in any effort except at public hearing? I find that difficult. And if you have the public hearing at night at PZC, people work at night, they can't come in. So if you have it during the day, maybe that offers another opportunity. I think this is just a very difficult spot that you put us in by saying these things. And like I said, I know that some zoning ordinances were put in place. Our zoning for land use was put in place in 2012, and things have changed. And because of that, we try to bring these ordinances forward and make some changes to them. But if we are not actively involved and just sit in your chair and sit in your house, it's kind of difficult to make the right decision. And because the facts are given to us, yes, but the facts are not always clear from either side.
And I think, Judy, that's the struggle that we're having right now. The county board members do want to participate, like many of us had said. I will say that the state's attorney, I don't believe they put us in a bad situation. They came here to present the facts to us, like what they are doing and what they are asked. The way I read it is the Constitution put us in this situation. And for the county board members to be able to do what we want to achieve, I think that's where we need to start. They're just trying to give us a heads up on preventing lawsuit and getting something rammed down our throat that we not necessarily wanted. And I'm not afraid to call it out right here. The state of Illinois did the same thing to us with the solar farms. You know, they come and ask us for permission, and if we don't give it to them, then we're at risk. So, they're just stating the facts. And as elected officials, we do want to go out and talk to our residents. So I think between both parties, we need to find a way to try to find a happy medium and get what we both want. So.
Yeah, because Joe, how do you go and ask for somebody to vote for you when you say, "Oh, I can't talk to you"? I don't know how you can do that. You cannot do that. You have to be responsible and speak with your public. Otherwise, how do you just say vote for me because, but I can't talk to you because the attorney has advised me to. It's a difficult thing. It's very difficult.
All right, I have, thank you, Judy, for that. And now a bunch more lights came on. Jackie Trenier.
I just want to ask about the PZC. I've never received meeting minutes from the Planning and Zoning Committee. There was comments about this the other day and we inquired about it and we actually asked if those could now be put on WebEx in case we just want to watch it. But we don't receive the minutes. And if we do end up going to a process where that is the only public hearing, we are going to need that access and we don't get it now. As far as I know, I have never seen minutes, just the outcome of their vote.
Mike?
So regarding the minutes, the Planning and Zoning Commission usually has to approve the minutes at the next meeting. Right. So the county board in the past has, directed us to make sure the land use cases move relatively quickly through a painless process as possible. And that being said, if the Planning and Zoning Commission meets and the next available land use committee is either the same week or 2 weeks later, there will not be minutes.
That's why we need to be able to watch the video. That's why we need to be able to watch the video. It needs to be recorded and put on YouTube like we do the other things. We may not have the actual meeting minutes, but we can watch the meeting. And right now we can't do that unless we go. And we don't get invites to those meetings currently. I mean, I don't, maybe I just never signed up for it because I just realized last year that you have to sign up for the different committees in order to get the minutes, or not the minutes, but the notice of the meeting. So I guess I've never signed up for that, so that's why I don't get it. Thank you.
Dawn Bullock.
So I'm trying to figure out a way to put this in my head so we pay you to go out and look at the land, to take the pictures, to have the open hearings at the PZC. And it feels to me like you are our lawyer in a sense. We hire you to be the lawyer to do all this work for us, and for us to go out and do it. Why are we spending?
We're clear, the state's attorney's office doesn't go out to these
No,
properties and take.
I understand that, but I mean,
Land use staff does.
just trying to
Yeah.
liken it to,
Got it.
and if I'm gonna pay somebody to go do all these things, and then I just take it on myself and go do it, well, then what's the point? It's like negating this PZC that we have that is already going out and doing all those things. I appreciate being on land use, the many pages that are required to go through before we go to these land use meetings. I spend many weekends just looking at land use because the meetings come up the first of the month, It is a lot to go through, but there are pictures, there are explanations, it's very, what you give us is very thorough. we don't get, what we do miss is the literal open hearing piece that happens at your meetings if we do not go to those meetings on our own. So that is one piece I think would be interesting to hear. However, I mean, really what you give us does give a lot of the answers to the questions that we would have. It is just a matter of taking the time and going through all of it. I don't know if you guys have any way of like, not putting all the big cases in one meeting together. That'd be great.
So,
But,
so
you
to
know.
clarify, the state's attorney's office has nothing to do with that. Matt and I represent an independent elected official. This is just one of the things that we do. We don't control PZC. We don't control any of those things. Some of the things that you're seeing are being put together by the land use. Matt and I have nothing to do with that. We can't control it. We're like I said, we're representing Mr. Glasgow, and that's only our role as your advisor, your legal advisor, to sort of train you.
Okay. In order to try to wrap this up, I have 2 more county board members, and then I would allow the county executive to chime in if she would, okay.
I'm just making sure she recognizes staff versus.
All right, well, I'll give you an opportunity to jump in at the very end, and so let's go to Mr. Balich and then Micah, and then we're going to wrap up.
Yeah, when I asked that question earlier about talking to somebody about a idea, a project, and you said that's a no-no, I'm asking Joe to ask the state's attorney for a written legal opinion about whether or not a county board member can meet with somebody and discuss a idea, because it's at the time when they call you, there's nothing else but an idea. It's just is this a good idea or a bad idea? If I tell them I think it's a good idea, don't mean I'm going to vote for it because I didn't hear the evidence from the public hearing. I just tell them I think, yeah, go ahead and move on it. I'm not telling them how I'm going to vote. I'm not saying anything other than I like the project. So in order to go forward with this, if you're going to say that, I want a written legal opinion. I never asked for that from you yet, but in the past I've asked for stuff. But this time it's important because everybody on this board got to be getting the same type of calls I'm getting. And if they don't talk to them, at least just talk to them and find out what they want. What the hell are we there for? So that's why I'm saying, I think that, you're going strictly by the law as you're interpreting it. So if you can show me a legal written opinion from the state's attorney that says you cannot talk about anything that's an idea with a constituent, because that's all that is when they call you and it hasn't gone to land use. There's no idea whether it's going to go to land use or not. They just want to get your opinion whether you think it's a good thing or a bad thing. And you can't tell them what you think.
Gentlemen, is that something that you think you can draw up for Mr. Balich, or is it, do you have to separate it between a public hearing or a land use case versus any other case?
Perhaps if we got we think we need a little more than, so the question of whether it's a good thing or a bad thing. I may think that having another grocery store is a good thing because it makes my day easier to have a grocery store outside my neighborhood. That doesn't, there's a lot of factors here. So we need to know exactly the question that's being asked. So whatever is submitted to us, if that goes through your rules, we can address that as per the rules.
Okay, it sounds like they want a specific question,
Well,
Steve, and I don't know.
Very specific. If Chuck calls me up and says that he wants to build a ice skating ring on his property, and he says, "What do you think?" And then I look at it and I go, "I don't see a problem with it." I'm not saying I'm going to vote for it. I'm not saying I'm not going to vote for it. I'm just saying, looks like a good idea. The neighborhood needs one. I'm not even saying that. I'm just saying it looks like a good idea because I never say, well, the neighborhood needs it. They might, but I'm not. I'm just saying, okay, I think it's a good idea. So what in the heck are we there for if we can't tell a constituent that it's a good idea? Tell me. I mean, in other words, I'm supposed to tell everybody to go jump in the lake?
No, that's not been our advice at all. But I think that what I'm saying is reducing it to writing and then presenting it to leadership is important because you said two things that I think are completely different. I don't see anything wrong with it. Well, that can be interpreted with, I think it's legal. I think it's a good idea is a different thing. And when this all happens, and I'll just put it out there, you'll be sitting in a deposition and they'll say, well, Mr. Balich, didn't you say this was okay? And you'll say, well, what do you mean? Well, didn't you say you'd vote for this when you talk to the person? It muddies the record. That's all we're saying. And we're not.
But it's Kevin, this is even going to land use or any idea if it's going.
I think-
Well, and that's the point.
They're just asking, should I move forward with it? Maybe.
Correct.
I'm not telling them I'm going to vote.
Reducing that to writing, what you're exactly asking us, is important for us to issue a written legal opinion. So if you want to present something to leadership through your county board rules, we will certainly address that question if it's brought to us. But we need that also reduced to writing so that we're not chasing a target.
Well,
And I want to put a final point here is we're not saying, and I keep going back to this, you have two roles here. You are elected officials. Absolutely. You have those things. And for, I don't know, 80% to 90% of your work, you are responding to constituents, you're taking meetings, you're doing those sort of things. The Constitution, not Matt, not anything else, has said in these things, you can only consider, and there's court cases abound about what you can consider. Matt and Kevin aren't telling you, or State's Attorney Glasgow is not telling you that you can't do your job. We're saying that a judge is going to go strictly by the law. That is, here's what the law is. We can show you what the case law says. And if your answer to that question is, how am I supposed to represent my district? The judge is going to say, well, that's not a LaSalle factor. If you're the only thing you're doing here is representing your district for whatever thing outside, that's going to cause you a problem. That's all Matt and I care about. We're not trying to do anything else other than to get to a situation where the judge says, and it's going to say at the end of the opinion, the state or the county board of Will County acted arbitrarily and capriciously in denying this zoning, or they should not have granted the zoning because they did not consider the relevant information.
Well, specifically, I would say that if you're not telling them how you're going to vote, you're just telling them that your idea is a good idea.
Yeah, Steve.
The people like that.
He
Come on.
understands.
What are you supposed, if you come to me and you ask me, is it a good idea to wear a winter coat when it's 90 degrees? And I tell you, no, it ain't a good idea. Then you walk away. Or if, you know what I'm talking about?
I get what you're saying.
I'm just saying yes or no to their idea. I'm not telling them I'm on vote, just yes or no. And you're saying you can't do that? That limits us to any conversations about anything.
No, we're talking specifically about land use cases.
I know that. Any kind of conversation concerning land use that completely takes everything out of the picture, and a person that doesn't know needs just a little direction. Do I like it? Do I not like it?
Perhaps maybe the answer is, hey, you should
And
discuss that
I'm
plan
not
instead.
saying how you vote. That's the important thing. You never
Okay,
tell them
Steve,
how you're going to vote.
We
So,
understand.
I'm asking Jim, can you ask Joe to get me a written legal opinion on an idea can't be discussed with a constituent?
I don't know what Jennifer has anything to do with it, but
Well, Jennifer
what a-
probably agrees with me.
well, I think a lot of us do, Steve. A lot of us do. We do want to
I
talk
mean,
to
I
our
think
constituents.
this is stupid.
All right.
I never heard such stupid things that you can't talk to somebody about an idea.
Okay. All right. Sherry Williams, Leader Williams has not had a chance to speak. Let's make your closing question, please.
Okay, well, this is basically more of a comment and possibly a question too. But I just want to say, I'm always going to talk to my constituents. Now, what I tell them, that's a different story. So I think that's what we're saying here. We can always talk to our constituents, but we can direct them in different places and in different ways. So if they contact me, I am going to respond. We just have to know which way we're going to respond. And so I guess what I'm hearing here is, as long as this is going to be a part of a public hearing that we are involved in, then we need to be careful of what we're telling people. Is that what we're saying?
Sounds fair.
Yes.
So, and if we're not in that public hearing, then that doesn't really apply. We can talk to them and deal with it as we see fit then, if that's the case, right?
Very broadly, yes.
Yeah. decision that's made by this county board is based on the information provided at that public hearing.
Can't hear Matt. You have to turn your mic on.
Sorry. Better?
Yes, thank you.
The decision that this county board made is going to be based on the information provided at the public hearing. That's what I said.
Okay. Thank you.
Yep.
All right. Thank you, gentlemen, for the questions and answers and the information.
I have my light on.
Well, all right. I'll tell you what, we can go on all afternoon then.
It's
Go
gonna
ahead,
be quick,
Micah.
I'm
Go
sorry.
ahead. Go ahead.
I agree with Jackie Trainier about the minutes and the WebEx option. Is it also possible to have the land use department kind of lay it out to the applicants that, you know, the county board will be voting on it, but you cannot have access to them? Something. Is there a way to tell them, don't call us? Or why they can't? I mean, I don't know. I mean, you're the ones that are having access to the applicant, to our constituents in these matters. So I'm just curious if there's a way that you can assist us with this.
We will evaluate that question and look for a response soon.
Okay, I appreciate that. Thank you. That was all, Joe.
Anyone else?
Joe, I'd just like to say something, if you don't mind.
No, of course not.
I know. So so one thing is a comment. It's like, well, we are told that by state statute, we're required to have a public hearing at PZC. And that's where we do have one public hearing, but we also have another public hearing at the county board. So that's a policy decision that the board could decide to change, to say we're only going to do public hearing at PZC, or maybe we're going to do a PZC and land use, or maybe we're going to do a PZC and county board, or we're only going to do it one spot. That's a decision that the board needs to make. Correct?
Correct.
Okay, so then the other decision, the other thing that I'm not sure of is if all 22 of us county board members go to the PZC meeting and we sit in our chairs in the county boardroom, because where else are we going to sit? Because I know many times that entire galley is full of people. So I don't know how. And then also and I know you may not have the information now, but I'd like the information. How is it that a county board member could then interact? And isn't it confusing to the applicant when they're speaking to appointed people on the PZC board and their elected county board member is sitting in the room and they're the ones who are accountable, because appointed people are not accountable. I mean, maybe to whatever statute we have, however it's interpreted. That's my question. And if you don't have an answer for that today, I'm fine with that, but I would like to have that as to how then would the board members participate in the PZC meeting. That's what I have, Joe. Thank you.
Would anyone like to respond or take a moment to try to get that answer later?
I think we need to look into it.
Okay. All right. County executive?
I want to add another question then too. Again, I'm with these folks here in this one. I think they need to talk to their constituents, but I get it. And that's my question regarding, is the hearing different from everything else? Because then technically, if we're not supposed to take any judgment passed on the hearing, why do we have a committee hearing? They're listening to everything in a committee. So there's that as well too. If they can't take that into consideration, if the county board members aren't asking questions, so that's going to be another wrench in this as well. If only supposed to listen to the hearing, we shouldn't be having a committee meeting with that either. So something else to add confusion.
Okay. Open it up for any more questions or comments? No? Okay. All right. Thank you guys for the information, gals, and answering the questions as many as we could. I'm sure it's completely more confusing now than it ever has been, but the information is there, and it looks like we are interested in trying to get the information out to the public as much as we can, what our limitations are.
Do we want to reschedule the FOIA or?
How long of a presentation is FOIA?
I have maybe 5 minutes of speaking and I was just going to do any questions.
You know, I would like to entertain just because these issues have came up in a case that we had listened to. So if you wouldn't mind, let's try to rip through that
Sure,
fairly quick.
sure.
Thank you.
Yeah, and so I think for the overall idea for you guys is, this is just an overview for you. You know, at the state attorney's office, people like Matt and I are responding to FOIAs. Chuck is responding to FOIAs. The minutia of actually responding to the FOIAs is not what I want to present to you guys, because you're not going to be the ones doing it. The basic overview here is, okay, what's a record under FOIA? Because FOIA only applies to public records. And the statute basically takes great pains to say that everything is a public record. Records, reports, forms, writings, letters, memorandums, cards, tapes, recording, electronic data. It goes through everything. And they basically say even stuff that we don't know about now. When the statute came into effect, there was no cloud storage. There's no sort of thing. Basically, anything where the government is storing data is a potential record. It just has to be reduced to some sort of writing or physical form. So basically, everything is a potential public record. So that's your first universe of bringing all those things in. So the case law has kind of said there's basically two things that you look at then to determine whether a record is actually a public record. First, it has to pertain to the transaction of public business. So just because, I'm trying to think, you know, when Chicken and Spice was down near the county building, just because there was some menus from Chicken and Spice down at the county board building, that doesn't make it a public record. It's not pertaining to the transaction of public record or public business. So whereas Matt was talking about factors where, you know, you kind of weigh these things, these are elements. You have to have both. It's pertaining to the public business. And then you also have to prove that it was prepared by the public body, used by the public body, received by the public body, or possessed or controlled by the public body. So something may pertain to public business, but if it's you know, Joe Coot Public's notes out in the gallery, it wasn't created, it wasn't retained, it wasn't possessed by the public body. If you can't show both those things, it's not a public record, it's not subject to FOIA. That's sort of an analysis that, you know, normally Matt or somebody else, I myself in the office, would do that detailed analysis. But those are your two things. Is it about public business, and do you guys have access to it, essentially, is what I would call it. You know, I think of particular interest to the county board members is some of these electronic communications. So, you know, you're at home and you're texting about, you know, we're going to amend our food ordinance or something like that. The two things that, you know, might subject you to them being public records and then subject to FOIA is, okay, is a majority of a quorum of any of your committees or the public body on this text message thread. So if you know 4 or 5 of you are texting, you're probably subject to FOIA then. The other thing, which is a newer development in the law, is you know, we're in session right now. You guys get a message that says, hey, I think you should push back on the state's attorney's opinion on this from constituent. You're acting as a body right now. That's part of the give and take. That text message might be subject to FOIA as well, because it's take out the age of electronic communication. That sort of information would have been transported to you in an open meeting. The courts have said basically you can't text with constituents and avoid the discourse in public by just you know, getting them on your phone during a meeting. So if you're in session and people are sending you things, you know, lights should go off. This may be subject to FOIA. And whether you say, hey, I can't respond to that, or just ignore it, you know, you don't want to create additional records now. You know, Member Brooks said, yeah, I think Kevin's really bad at his job. And then I can go back and FOIA that. So those are the two things. How many people are involved and where are you at? Those can create some non-traditional FOIA issues that we don't often think about. We certainly think about our policies, our budgets, those sort of things, but those are sort of wrinkles that the courts have sort of struggled with recently and kind of put them out there. So, you know, I think a lot of what we're always discussing is, what does this look like when somebody says, hey, you didn't give me my record? You know, it ends up in litigation. I've litigated a lot of cases under FOIA. Basically, you're against, whereas the presumption for Matt's side was that the county board acted correctly, The presumption is you acted wrongly in FOIA. The presumption is those records were open and available. And so I have to then, or whoever else has to establish by clear and convincing evidence that either it's not a public record or one of the, at this point, I think there's like 60 exemptions applies. And I have to establish that by, in a court saying, no, that text message wasn't a public record because it was about lunch plans. It had nothing to do with county business. Or, something we run into frequently in some of our other clients is it's about a pending criminal case. Sure, it's a public record, but there's an active homicide going on. And I have to, bring somebody into court saying, yes, I'm Detective Smith. We're currently investigating this homicide. If somebody knew about this. So whereas the record is stacked in your favor in a land use case, it's the exact opposite in a FOIA case. So, that's something to consider is how do we get around, I shouldn't say get around, how do we get past these burdens that are pointed at us? So the tie doesn't go to the runner in any case in FOIA. The runner's got to be safe by 100 feet, which that's not what the base paths are. That's a bad example, but neither here nor there. So the only other thing that I want to say before taking up to any comments you might have or questions is what is in the record then? The case law is pretty clear that if somebody says, hey, I want to see your budget for this year, and we turn it over, they don't get that come back under FOIA at least. They come back and say, well, explain to me what all these things. I can't understand the budget. Your obligation finished when you provided that record. You don't have to provide an interpretation of that record. You also don't have to answer questions. If they say, well, how are we supposed to explain that you spent $600,000 on this project? Again, that's part of your political route, but it's under FOIA. You don't have to then engage in a back and forth of answering questions about a document. Those aren't records, and we get those all the time. Explain to me what you did here. I'm asking for this under FOIA, and then we will deny it and say it's not a record. If a document's not in your possession anymore, it's not subject to FOIA. I actually had a case, I'm a little bit ashamed that this went up to the appellate court, an inmate FOIA'd milk cartons, and his basis was they were expired. The appellate court, rather than making the decision that a milk carton is not a public record, they said it went in the trash after it was used. It's no longer in their possession. It can't be FOIA'd because how would you get a hold of it? Don't take that as I'm saying destroy records so that they're not subject to FOIA. That would then impose liability under the Local Records Act, and nobody wants to go to jail over that. And then, third-party materials, as I said, that don't concern public business or aren't in your possession. Somebody's notes, hey, I want to know what that guy was writing down on his notepad during your public hearing. Look, it's not a public record. It's somebody else's. It may pertain to public business and it may be very important. It's not a record. But otherwise, those are very little small exemptions to the rule. Just think of it as basically all the things the government creates could possibly be subject to FOIA, and a constituent could be asking to see that. So,
Any questions that come to mind? Sherry Newquist.
So I'm not sure I'm clear on this. Let's say I'm at a land use meeting and I'm taking notes. Are those notes FOIAble?
They certainly could be. They fit the meeting or the meaning of a public record. Then we would have to look at them. What I'll call stage 2. Do they fit any exemptions? And that's going to be a fact-intensive decision. So if it's like you're at a meeting and you're taking notes, and it's just your preliminary thoughts, no decision's been made on this, we would probably say your notes are preliminary drafts. The county hasn't acted officially on anything. So that would then, they could be public records, and I think they likely are. It's whether they're exempt.
So basically don't write, I wouldn't vote for this project for any reason at all because this guy's a jerk, or something like that.
I early on in my career here, somebody gave me a very important piece of advice, and I'm sure other attorneys have heard it too. Don't ever write anything down that you don't want to heard read back to you in a deposition. And that's what will happen, or it'll be in the patch, or it'll be on whatever social media. Because if we can't establish by clear and convincing evidence that that thing was exempt, yeah, your whoever's upset about it is going to take a scan and put it right on their Facebook and say, here's what member Newquist thinks about me. Yeah, you run that risk. And FOIA is a very fact intensive, it's impossible, even when we do trainings for the FOIA officers, it's impossible to answer every scenario because the courts often struggle where, there's factors in certain exemptions in FOIA that require us to balance 4 factors. And I've argued cases where it's like, the attorneys are at loggerheads. What's the public interest? Well, I think there's absolutely no interest. I think it's meant to embarrass somebody. And they're going to say, well, no, we're looking to establish public corruption or something like that. It gets very fact intensive. But, if you think it might be subject to FOIA, it probably is.
Judy, did you have a comment or question?
I have a question.
Yeah.
So Kevin, for emails, let's just say pertaining to something, how long are emails available? I mean, sometimes, we have so many emails, and trying to negotiate emails in an iPad is the most ridiculous situation anybody can try and deal with. So sometimes I delete emails because I just cannot have 5,000, 7,000 to look at all the time when I'm trying to find information about other stuff. So as far as that goes, how long is the email actually available? I mean, I know if I delete it from my iPad, is it still available?
Yeah. So all I can speak to is specifically is like your county email. The last I had any conversation with IT, it was like 7 years. And then that's certainly an important fact, Member Ogalla, that we do when we're training FOIA officers is just because somebody deleted it off their computer, the first thing that's going to happen with either a FOIA or a subpoena when they ask for emails is somebody from one of the departments is going to call Jason Donish and say, hey, Jason, run a search term for county board expenditures on whatever the thing is. And Jason's going to pull those if they exist on the server. I believe it's 7 years. That's the last information I have.
Okay, so like if there was a particular email that was sent from, say, my email to somebody else's email, that information is available for 7 years.
Correct.
And do you know then, do you know this? Let's just say I go to the library and I forget my brain and I just leave my computer sitting there wide open and somebody gets in and sends emails from my email. Can you find out where that email was sent from? Like if I'm logged on, I guess your iPad's different, but if you have a computer and you're doing county business and you use the local Wi-Fi, let's say at a coffee shop, that's a good one. And somehow you step away to grab your coffee because it's ready and somebody comes and sends an email. Would they be able to see that IP address that was sent as you were at the coffee shop at 143rd and LaGrange? If there is one, I don't know. And an email was sent and you say, well, I didn't send it. You'd be able to go ahead and see that on that day, an email was sent from that with that IP address.
So I'm a simple lawyer. That's a really good IT question. Is your question whether that data is available or whether somebody could FOIA the IP information, that the metadata and other things that come with?
Yeah, is the metadata available also for 7 years?
That is a very good question. That is an county IT. I don't know. In my experience, like I said, I've only had to pull the actual emails. How that could be extrapolated from the email file, I'm just a lawyer. I don't know. But or is your question also whether somebody could FOIA that information?
Well, both. I mean, if it's available, they could obviously FOIA it.
Right. And then the question we would have to look again as case by case thing. Does that create a security vulnerability? Does it impact something else? Then we would be in exemption land. Yes.
Okay, that would be great to know because I know I had a situation with myself where someone was using my email and sending emails and deleting emails, and I wasn't aware of it. And I know when I was the chair, I sat with my staff and we were like, well, it seems like people are reading emails and or listening in. We didn't know if the place was bugged or what was going on, but I was just curious to see if that information would be available and for how long.
That would be a question for Jason and his staff, who store the emails in their servers.
Thank you.
Anyone else from the room? Sherry?
This is my last question, I promise. Let's say I send Kelly an email from my personal email to her personal email, and it's more political in nature. Like I'm saying, oh my God, I can't possibly vote for this because I'll get clobbered by my constituents. Is that FOIA-able?
Well, you straddle a very, very thin line there. You're talking about the transaction of public business. I'd say arguably yes, because you're not saying, oh, I've got to raise a lot of money. That I think would be, outside FOIA. You're not talking about any transaction. Look, my opponent is killing me. You're both county board members, but it's not the transaction of public business. We'd advise you not to do that on your county email. But your example, your personal email, it still could be subject because you're set, and it kind of all goes back to the land use thing. I made this decision because I want to win re-election, not because I did X, Y, and Z. So it could be. It's certainly, I would say more likely than not, it is at least subject to FOIA.
But in theory, we'd have to volunteer that information, correct?
In theory, now the question is that's just the first step. Again, if somebody were to push the issue and perhaps somebody had inside information that you two were texting or something like that, well, then now we have subpoenas are being sent out and things like that. So it's voluntary until it's not when somebody pushes the issue.
Got it. Thank you.
So with this FOIA conversation, if you had just one last word of advice, like you had said earlier, if you think it's FOIA-able during county business, just try not to respond, try not to participate.
Yeah, I think that's exactly it. If you think it's FOIA-able, if it even gives you the slightest sense that it might be FOIA-able, it's FOIA-able. And then we're talking about how do we, if it's legal, how are we trying to hit the exemption for all the myriad of things that are exempt under not only FOIA, but the statutes. All the statutes have certain things that may not be part of FOIA, but they say they're exempt from FOIA.
Okay. Well, we covered two very important topics. Thank you again, folks, for coming in. It might have been a long time coming, but it's good to try to update our knowledge and get some information on our job and what your guys' jobs are as well. So with that being said, there is no other new business, I don't believe. Public comment related to matters under the jurisdiction of the county. Is there any public comment? And we probably can't use that information unless it was under a public hearing. There are no announcements or reports by the chair. No need for executive session, so I will entertain a motion to adjourn. Motion, second Freeman. All those in favor, please say aye. Aye. Anyone opposed? Motion adjourned.